The framers have experienced firsthand the framers had experienced firsthand the dangers of a monarch who was above the law, and they adopted a system of checks and balances to avoid those dangers. They designed a constitution that would ensure an effective and energetic president under Article 2, but one who was accountable to justice under laws passed by Congress under Article 1, enforced by the executive branch under Article 2, and adjudicated by the courts under Article 3. That careful design leaves no room for an implicit and previously unrecognized rule categorically immunizing the president from accountability for criminal conduct involving the misuse of his office. The claim of absolute immunity for a former president's official acts violates established separation of powers principles. Petitioner, petitioner being Donald Trump, asks this court to create a doctrine of absolute criminal immunity under which duly enacted federal criminal statutes cannot be enforced against a former president based on conduct involving official acts, unless he has been impeached and convicted by the Senate for the same conduct. Petitioner therefore asserts a new presidential power to be free of congressional commands in criminal statutes in virtually all circumstances. Under that framework, the president's power is at so that's Donald Trump's argument. Now, this court, the Supreme Court, analyzes claims of presidential power under the framework set in Youngstown. Under that framework, the president's power is at its height when he acts pursuant to an express or implied authorization of Congress, and where president takes measures incompatible with the express or implied will of Congress, his power is at its lowest. In that third category, the president can prevail only if he asserts an Article 2 power so conclusive and preclusive as to disable the Congress from acting upon the subject. That principle flows from the Constitution itself. Article 2, Section 3 requires presidents faithfully execute valid laws made by Congress under its Article 1 authority. The court has rejected a claim of presidential power when it contravenes Congress's express enactment and so falls within Youngstown's third category. Its third category being, when it works against Congress, express will of Congress, then it is president's power is at its lowest. So for the purpose of just letting you know, the second one is being Congress has not expressly legislated on a matter. Zone of twilight exists in which the president and Congress may have concurrent authority. That's not the case here. The case that here is that Donald Trump acted contravening the express will of Congress as applied in the statutes that he violated. In claiming here that the Constitution prevents all federal criminal statutes from applying to a president's official acts, petitioner does not purport to identify any exclusive and preclusive power that would justify such an exemption. Framers did not provide any explicit textual source of immunity to the president. The text of the Constitution explicitly addresses the privileges of some federal officials, but does not afford the president absolute immunity. The Constitution's structure presupposes a government under law, not an absolute shield that places the president above the criminal law unless he is first impeached or convicted. Recognition of the petitioner's immunity claim would prevent Congress from applying criminal laws equally to all persons, including the president. His immunity claim thus contradicts bedrock principles by placing the president above the law. A constitutional exemption for a president from criminal laws that govern everyone else. That itself is against the whole idea of the law applying equally to everybody. Criminal prohibitions at issue here illustrate that point. They prescribe the conspiracy to defraud the United States by defeating its lawful functions, substantive and conspiratorial efforts to obstruct official proceedings, and a conspiracy to injure or oppress the free exercise or enjoyment of any citizen's constitutional rights. Petitioner has not argued that the Constitution vests the presidents with authority to perform the conduct prohibited by those statutes, or that president would be unable to fulfill his constitutionally assigned role if he were prosecuted for such inherently culpable conduct. Yet petitioner's immunity claim would not only exempt the president from those statutes, it would free him from federal criminal accountability for any criminal for every crime committed through official acts, absent impeachment and conviction. The Article 2 does not require that result, and it is therefore foreclosed by the fundamental separation of powers principle that the president is bound by valid statutes unless Constitution exempts him.